of 1999. A recently concluded training session in Nairobi, Kenya's Chief Justice Martha Koome said judiciaries of member countries looks to the EACJ to give standards that they can't emulate. Joining me now to discuss more about the court's mandate is Honorable Justice Nestor Kayobera, who is the president of the EACJ. You can see him on your screen right now. He's also joining us into this conversation. In this conversation, rather, is His Worship Euphnalis Okubo, who is the registrar of the EACJ. Gentlemen, thank you so much for joining us here on Bottomline Africa today, just to talk to us about the EACJ, what it means in terms of their mandate, the sort of rulings they've made, whether local countries within the EAC are adhering to the court rulings of the East Africa Court of Justice. So let me begin with the president of the court, that is Honorable Justice Nestor Kayobera. Talk to us about the just concluded, workshop that was held here in Nairobi, attended by the Chief Justice of the Republic of Kenya, Martha Koome, and also the Attorney General, Kihara Kariuki. What was the workshop about, and what should residents within EAC expect from judges after the workshop was done last week?
Yeah, thank you very much for the interview. As you rightly saying, we have been in Nairobi from 12 to 21st of July this year. We have been holding some trainings, workshops on good governance and the rule of law, on constitutionalism in the East African partner states, but also we had a plenary of the court, as well as adoption and validation of the midterm review of the Eastern Court of Justice. During our stay in Nairobi, we also got opportunity to meet with the Chief Justice of Kenya, Lady Justice Martha Koome, and we discussed about the relationship between the Eastern Court of Justice and the national judiciaries, especially Kenya. And now Kenya is the chair of summit. Ipso facto, the Chief Justice of Kenya is also the chair of the Forum of Chief Justice. We also got opportunity to meet with the chair of council, Honorable Adam Mohammed, to discuss about the relationship between the court and the council of ministers. As you know, by the treaty establishing the community, the Council of Ministers is the policy organ of the community. So the judiciary, being the Eastern Court of Justice, being the judicial organ of the community, we thought it's better that we meet also with the chair of the council, which is the policy organ of the community. As you say, our activities were opened by the Attorney General of Kenya, but also they were closed by the chair, the Chief Justice of Kenya. So we're trying to see how we can collaborate with the judiciaries. And from those trainings, we thought now it is better, as we are approaching the 20th anniversary of the court, it's better that the court be known by the citizens of East Africa. So we think after the trainings we have been holding in Nairobi, now the court will be known. Mm-hmm. And as we are saying now, we are talking with you, with the Kenya, that at least now the court will be known, that the court can be accessed by the East African people, but the court can be also, yes.
So Justice Kayobera, just hold on to that thought about, resident citizens within the East Africa community getting to know more about this court. We shall be delving into that later on. But let me bring in the registrar of the EACJ, that is Okubo, into this conversation. And the president of the court, Okubo, has actually explained to us, narrowed it down to us about the strategic plan that the court has when it comes to some of how they'll be handling court cases that will be taken to the EACJ. But then kindly talk to us about the role of the court, or rather the jurisdiction, and you're highlighting for us also on the landmark cases delivered by the EACJ.
Thank you very much. Generally, or on a broader sense, I can say the jurisdiction of the court is to interpret the applications of the treaty to member states. But as I say that, maybe also let me make it clear that any country that violates its own laws, it has gone to parliament, it has passed its own laws, you automatically then also violated the treaty. Because Article 6 of the treaty that talks of the fundamental principles, one of the major fundamental principles which partner states must observe is adherence and observance of the rule of law. So you cannot go to Parliament, pass a law yourself, and then breach it. If you do that, then you've automatically violated the treaty. And in fact, most of the cases that come to the court come around the violation of the fundamental principles of the treaty. So that is a major jurisdiction of the court when it comes to its mandate. Secondly,
allow me to cut you short. Allow me to cut you short, Registrar, because you're saying that countries that are part of the ESCJ are bound by the court's ruling. But we've seen several countries within the ESC finding it hard to implement some of the rulings that have been given by the court. So how do you handle that?
There is a procedure specified in the treaty and in the rules. First of all, when it comes to implementing the decision of the court, you are supposed to follow the rules of civil procedure in your national court. For example, if it's judgment against you, I'll take that judgment and file it in the High Court of Kenya. Kenyan High Court adapts it and executes that judgment using the civil procedure rules of the High Court of Kenya. This is because, first of all, there's no international court that has its own mechanism for executing judgment. So we rely on the national judiciaries where you want to execute that judgment. So indeed, most of them have been executed. In fact, a study was done to see the level of execution of the judgments of East African Court of Justice, and 64% were found to have been complied with. The remaining that was not found to have been complied with is because there were declaratory orders. Now, a declaratory order, you don't have to do anything. All I'll do in a declaratory order, all the court will do is that a court will be telling you what you did, you violated the treaty, full stop.
All right.
So it is upon you to observe that. All
right.
So that you don't, yes.
All right. So, Justice Kayobera, you've heard from what the registrar said, you know, I don't want to call it a habit, but the decision by some local courts, you know, courts within the ESC, not to implement the court's ruling. You're only 4 months into the office. What is your plan? What is your strategic plan to ensure that the rulings that have been made by ESCJ are actually implemented to the letter?
First of all, thank you for the question. That is a very important question on the execution of the court's judgments. First of all, as you know it, execution of international court judgments, it comes from the goodwill of the partner states themselves. But the goodwill, as you know, the court is established by the partner states themselves. So the treaty is signed by the heads of states of the EAC governments. So what we said, what we did now, since our appointment, we had to go to see the heads of states. Right now, we decided to work together with the Secretary General, Dr. Mathuki. We decided to work together with the Speaker of EALA, my brother Ngoga. So we decided to go to see the heads of states. So we went to Kigali. We saw the president of Rwanda, His Excellency Paul Kagame. From there, we went to Uganda. We saw the president, His Excellency Museveni, the president of Uganda. From there, we went to South Sudan and we met with His Excellency Salva Kiir. And then from there, we went to Bujumbura, where we met with His Excellency Ndayishimiye. From there, we went to URT and we met Her Excellency Samia Suluhu Hassan. And then we went also to Zanzibar to meet with His Excellency Dr. Mwinyi. So, because of that, we thought the goodwill from the heads of state must be there. But from the record, as the registrar rightly said, the judgments of this court has been executed by the partner states, by the government of ESC, but also by the Secretary General. It is from the goodwill, but it will be strange to see the judgments of the court established by the same governments, partner states.
All right,
and then the same partner states do not execute those judgments. But
then, Justice Kayobera, yes, you've been moving from country to country, talking to the heads of state as a way of seeking their goodwill in terms when it comes to implementing the court's decisions. But there are those people who feel that there is somehow lack of independence of the court because of influence, you know, from maybe civil societies or even heads of state when it comes to cases that have been taken to the court.
To me, I think the court, the judgments, the judges themselves, they must be independent. Let me tell you, now from the upper division, we are 5 judges coming from 5 partner states. I don't know how can me from Republic of Burundi be influenced by a judge coming from Kenya or from URT or from Rwanda. It is impossible that me coming from the Republic of Burundi be influenced by any judge coming from Kenya or from Rwanda. It is impossible. That's one. Secondly, appointment of judges is provided for an Article 24 of the treaty. They must be independent. They must be impartial. So the discipline from the judges themselves, there is nowhere a judge from the Eastern Court of Justice can be influenced by any authority from either partner states or from their own judges. So it is impossible. We are working independently, impartially, with integrity as provided for under the treaty and Article 24 of
the treaty.
There is no influence whatsoever.
All right, tough talk.